A Supreme Court decision just dropped, and almost every headline you have seen about it is missing the most important part. Not a small detail, not a footnote buried at the bottom of a legal brief. The part that could actually affect your life, your rights, your future. Before we go any further, are you subscribed? Because what you are about to hear in the next few minutes is the kind of information most people will not encounter until it is already too late. Hit that subscribe button right now and let us get into it. Here's the headline that has been everywhere. Breaking Supreme Court 8-1 decision just changed both First and Second Amendment rights. And here is the problem. Half the people sharing that headline are celebrating something that did not happen. The other half are panicking about something they do not fully understand. Both groups are wrong in ways that could seriously hurt them. So before you repost that headline, before you repeat that take in a comment section, before you walk into a conversation thinking you understand what the Supreme Court just did, stay with me, because today we are going to do three things. First, we are going to break down exactly what this 8-1 decision actually says, what it held, and just as importantly, what it did not say. Second, we are going to explain how the First Amendment is tangled up in this story and why that matters to you, even if you think the First Amendment has nothing to do with your guns. Third, we are going to walk through real scenarios, situations you might actually find yourself in, so you walk away knowing what to do and what you should never do. Because the people who get hurt by decisions like this are not usually criminals. They are regular people who did not understand the rules until the rules were already being used against them. The case is called United States versus Rahimi, and the question the Supreme Court was answering is actually straightforward when you strip away the legal language. Here it is. Can the federal government take away someone's guns temporarily if a civil court has issued a domestic violence restraining order against that person and specifically found that they are a credible threat to someone's physical safety? That is the question. And the Supreme Court said yes. 8 justices said yes. 1 said no. Now stop right there, because this is where people go immediately wrong. They hear Supreme Court said the government can take your guns, and they either celebrate or panic. Both reactions miss the point entirely. Here is what the court did not say. They did not say the Second Amendment is weakened. They did not say an accusation alone is enough to strip your rights. They did not say states now have a blank check to disarm people they do not like. They did not say anyone going through a difficult personal situation automatically loses their firearms. What they said is very specific. If a court, a real judge, in a real hearing, has made a specific legal finding that you are a credible threat to another person's physical safety, then a temporary disarmament, while that order is active, does not violate the Second Amendment. Those details are not small print. Those details are everything. The person at the center of this case was not your average law-abiding citizen who made a mistake on a form. This was someone involved in multiple public shootings, someone under a specific court order because a judge found he was a genuine danger to others. That context matters enormously when you read the headlines. Now here is where this case becomes bigger than just the restraining order issue, because this decision did not just answer the question about one person. It sent a message to every single federal court in America about how to handle gun cases going forward. To understand that message, you need to know about Bruen. If you follow gun law at all, you have heard of Bruen. That is the 2022 Supreme Court decision that rewrote how courts are supposed to judge gun laws. Before Bruen, judges would weigh a gun law against public safety interests like a scale. Bruen said, stop doing that. Instead, courts need to look at history and tradition. Does this gun law have roots in the founding era? Does it fit how Americans have historically understood the right to keep and bear arms? That was a massive shift, and it was a significant win for gun rights in a lot of contexts. But here is what happened after Bruen. Lower courts went in completely different directions. Some judges started demanding what people call a historical twin. Meaning, if you cannot find a law from 1791 that looks almost identical to the modern law fails automatically. No exceptions, no flexibility. The Supreme Court in Rahimi looked at that interpretation and said, that is not what we meant. Stop doing that. The court said the Second Amendment is not a law trapped in amber. In plain language, that means the Constitution is not a frozen document. It is not a bug preserved in a block of ice, where nothing around it can ever change. The founders created a living framework of principles, not a museum exhibit of frozen rules. So instead of demanding a historical twin, an exact copy of a law from 250 years ago, courts are now supposed to look for a historical analog. An analog just means something close enough in the ways that matter. And the court said the two things that matter most are the why and the how. Why does this law exist? What danger is it trying to address? And how does it burden the right? How broad is it? How long does it last? How targeted is it? That is the new framework, and it affects every gun case being argued in America right now. Even though Rahimi is technically about domestic violence restraining orders, its real impact is that it corrects the course of how Bruin gets applied in courtrooms across the country for years to come. Here's something the loudest voices on social media will not tell you. The historical analog framework actually cuts in favor of gun rights in many situations because it forces courts to be honest. They cannot manufacture vague historical justifications. They cannot cherry-pick isolated examples. They have to show a genuine principle that matches the why and the how of the modern law being challenged. That means poorly written, overly broad gun regulations are more vulnerable now, not less. A court can no longer just gesture at public safety and call it a day. They have to do the historical work, and a lot of modern gun laws cannot survive that kind of scrutiny. Let us make this real. Let us talk about a guy named Mike. Mike is a responsible gun owner. Legal purchases, carries with a permit, never been in trouble. Mike is going through a messy divorce. It is loud, it is emotional, and it is ugly. One night he sends a string of angry texts. In his mind he is venting. He is hurt. He does not see himself as making threats. A week later, Mike gets served with a protective order. Mike's first reaction is the most dangerous thought he can have. This is just civil court stuff. It is not criminal. I will show up, explain my side. The judge will understand, and this will go away. So Mike gets the notice for the hearing and decides to let it slide. He thinks, I just have to stay away from her for 6 months? I can do that? No big deal. That is the decision that changes everything. Because if that judge signs an order that contains specific findings, specifically a finding that Mike poses a credible threat to his ex's physical safety, Mike has just stepped into federal firearm territory. Not because he committed a crime, not because he was convicted of anything, but because of what is written in that court document. Mike did not go to the hearing to defend himself. He did not realize that by letting it slide, he was legally conceding that he was a dangerous threat in the eyes of the federal government. Under the Rahimi ruling, the Supreme Court confirmed that as long as notice and a hearing were provided, the government can restrict your Second Amendment rights for the duration of that order. Mike waived his chance to fight the findings. The next day, Mike is driving to the range. He gets pulled over for a broken taillight. The officer runs his ID, sees the active protective order, and asks, "Do you have any firearms in the vehicle?" If Mike says yes, he is not just getting a ticket. He is facing up to 10 years in federal prison. That is how fast this moves. That is how real this is. And that is why understanding Rahimi is not about following Supreme Court politics. It is about protecting yourself from a system that does not slow down for people who did not know the rules. If you are ever served with any kind of protective order, the most important thing you can do is read that document carefully and understand exactly what it says. Does it include a credible threat finding? Does it reference violence or danger to physical safety? Does it explicitly address your firearms? Those specific words in that document are what determine whether you have a Second Amendment problem or just a difficult personal situation. You cannot tell the difference by guessing. You cannot tell the difference by assuming. And you absolutely cannot tell the difference by skipping the hearing. A major reason the law in Rahimi is structured the way it is comes down to judicial process. Notice, a hearing, a chance to respond. The system is supposed to give you an opportunity to be heard before your rights are restricted. But in real life, people get served with paperwork, assume it is overblown, skip the hearing, and the order gets entered by default, sometimes with findings that are far more serious than what might have happened if they had shown up with a lawyer and made their case. A default judgment entered because you did not show up carries the exact same legal weight as one entered after a full hearing. Show up. Get counsel. Take every piece of paper seriously from the moment it arrives. And one more thing people get wrong. Temporary does not mean harmless. Temporary in the legal sense can mean months. It can mean years. And if you violate the terms of that order during the temporary period, even once, you are no longer in temporary territory. You are in federal criminal territory. Legal fees alone for a federal firearms charge can run into the tens of thousands of dollars before you have even had a trial. And even if you win, the process itself, the arrest, the charge, the record, the stress, is a punishment that does not disappear when the case closes. Temporary only feels temporary if you follow the rules all the way through it. Now let us talk about the part of the headline that confuses most people. How does the First Amendment get connected to a Second Amendment gun case? The direct answer is that Rahimi itself is not a First Amendment case. But the reason these two amendments are being discussed together right now is because at the same time the Supreme Court has been defining the limits of government power in Second Amendment cases, it has also been drawing very clear lines around government power in the First Amendment space. Those two fights are happening in the same era, affecting the same communities, and pointing in the same direction. So here's the First Amendment issue in plain language. The government cannot pass a law that says no one is allowed to talk about guns. The First Amendment would strike that down immediately, and everyone knows it. But what if the government does not pass a law? What if instead, government officials quietly pick up the phone and call your bank? What if they have informal conversations with payment processors, insurance companies, and social media platforms, the private businesses that your lawful gun-related operation depends on to survive, and they suggest that maybe it would be a good idea to stop doing business with certain people? No law passed, no official order issued, no fingerprints left behind, but the result is the same. A lawful business is strangled, lawful speech is silenced, lawful advocacy is shut down, not by legislation, but by coordinated pressure channeled through private companies that are regulated by the same government officials making those phone calls. That is what courts have been calling backdoor censorship. In a case called NRA versus Vulo, the Supreme Court dealt with exactly this kind of approach. The government in that situation did not pass a law banning a gun rights organization. Instead, they used informal pressure. They signaled to banks and insurance companies that it would be unfortunate for their regulatory relationship if they continued doing business with gun groups. The Supreme Court ruled that the government cannot use its regulatory power to secretly pressure private companies into punishing speech or advocacy they do not approve of. That line was drawn clearly. Why does this matter to gun owners who are not running organizations or businesses? Because the gun rights debate is not only fought with laws, it is fought with access, it is fought with infrastructure. If you cannot process payments, you cannot run a gun shop. If you cannot get insurance, you cannot hold training events. If your content gets removed without a clear policy violation, you cannot build an audience for gun education. If an advocacy group gets cut off from banking services, it cannot fund the lawsuits that defend the Second Amendment in the first place. Think about every major Second Amendment legal victory in recent decades. Every one of those cases was funded by organizations that relied on donations, banking, payment processing, and public advocacy. If those organizations had been financially strangled out of existence years ago, Heller does not happen. Bruin does not happen. Rahimi, which ultimately reaffirmed the Second Amendment while clarifying its limits, might not have happened either. The First Amendment is the engine that powers the Second Amendment fight. You cannot defend a right you are not allowed to talk about. You cannot fund legal battles if you cannot process donations. You cannot organize politically if your organization gets financially strangled before it can act. Two separate amendments, two separate legal fights, but they are protecting the same person, you. Now let us talk about what you actually do with all of this. The first thing to understand is that the phrase credible threat is a legal trigger, not just language. In Rahimi, the court focused heavily on the fact that a judge made a specific finding, not an accusation, not someone's feelings, a judicial finding based on a legal process. If you are ever involved in any kind of protective order situation, those specific words in that document are the dividing line between a difficult personal situation and a federal firearms problem. Know the difference before you assume it does not apply to you. The second thing to understand is that showing up is not optional. The entire legal framework the Supreme Court relied on in Rahimi is built around the assumption that you had the opportunity to be heard. If you skip your hearing, you are not just missing a court date. You are legally forfeiting your chance to challenge the findings being entered against you. You cannot complain about a right being taken if you did not show up to defend it. The third thing is about your words and your online behavior. You might be venting, you might be doing dark humor. In your mind, context makes it obvious. But a screenshot has no context. A government proceeding does not grade on intention. It grades on what was filed and what you said. The First Amendment does not make your words disappear from someone else's screenshot. And if those words are used as evidence of intent or threat in a civil or criminal proceeding, your belief that you were just being edgy is not a legal defense. The fourth thing is about knowing your rights in a direct encounter. If you find yourself in a situation where law enforcement is asking questions and you feel the conversation shifting from a greeting to an investigation, you need to know what to do. Fighting, being rude or aggressive, gives the government exactly the kind of conduct evidence they need. But explaining, volunteering information, filling silence with words, that gives them the admissions they need. You have a right to remain silent. You have a right to ask whether you are free to go. If the answer is no, you stop talking and you ask for a lawyer. Those are not tricks. Those are constitutional rights that exist for exactly these moments. Use them. The fifth thing is a longer game. Pay attention to what is happening to the infrastructure around your rights. If your payment processor drops you with no clear policy violation, document it. If your bank closes your account with vague reasoning, document it. If a government official's statements correlate suspiciously with private companies suddenly refusing service to lawful gun-related businesses, that is a potential First Amendment claim. The Volo decision means that fight is winnable, but only if people recognize it when it is happening and take it seriously. Now let us clear up the myths that are circulating, because a lot of what is being said about this decision is flat wrong, and believing wrong information can cost you. The first myth is that this decision means anyone accused of anything loses their guns. That is not what the ruling says. The Rahimi decision is grounded in a judicial finding, a legal process, and a specific determination of credible threat. Accusation alone is not the standard the court applied. The court emphasized that notice and a hearing were provided. That is not a formality. That is the constitutional protection built into the framework. The second myth is that the court opened the door to broad gun confiscation. Also wrong. The historical analog framework that Rahimi reinforces is a constraint on government power, not an expansion of it. Courts now have to justify gun regulations with genuine historical principles, not political reasoning dressed up as legal analysis. That is a higher bar for the government than most headlines suggest. The third myth is that the First Amendment stuff does not affect regular gun owners, already addressed above, but let it be said plainly. If you have benefited from any Second Amendment legal victory in recent decades, you benefited from the speech and organizational infrastructure this First Amendment fight is protecting. You do not get one without the other. Let us also talk about a scenario that does not get enough attention, the business squeeze. Imagine you run a small operation. Maybe it is firearms training. Maybe you sell accessories or components. Everything you do is completely legal. One day your payment processor sends a vague email saying your account no longer meets their terms of service. No specific violation cited. A month later, your business bank account gets flagged for review. Then your insurance broker calls to say your renewal is being declined. You are not being arrested. No law is being broken against you directly, but your ability to operate is being systematically dismantled through private companies acting in coordinated ways that benefit someone who would prefer your business did not exist. This is the First Amendment fight made real. And because of the Volo decision, you have legal standing to push back, but only if you recognized what was happening, documented it carefully, and connected it to government pressure rather than independent business decisions. That distinction matters enormously in court. Document everything from day one. Here is another scenario worth running through. You are frustrated. Something happens in the news. You make a post on social media. You are venting, being edgy, using the kind of language your friends understand in context. In your head, it is obvious you are not being literal. But a government agency takes a screenshot. That screenshot gets filed as evidence in a proceeding you do not even know about yet. You think the First Amendment protects you from consequences, and in many cases you are right. But there is a meaningful difference between protected speech and speech that can be used as evidence of intent or credible threat in a civil or criminal proceeding. The First Amendment does not remove your words from the public record. It does not stop anyone from screenshotting them. It does not prevent them from being used against you in a courtroom if a judge decides they are relevant. Think before you post. That is not a limitation on your rights. That is wisdom about how the real world works. Here is what you need to walk away with today. The Supreme Court's 8-1 decision in Rahimi said the government can temporarily disarm someone who has been found by a court, after proper notice and a hearing, to be a credible threat to another person's physical safety. It also told every lower court in America to stop demanding perfect historical twins and start applying genuine historical principles when judging gun laws. That is not the end of the Second Amendment. It is the court refining how the Second Amendment gets defended going forward. Bruin is still the standard. Rahimi is the instruction manual for applying that standard correctly. And the First Amendment fight happening in parallel, the Volo decision, the debanking issue, the pressure on gun businesses and advocacy organizations, is protecting the entire ecosystem that makes Second Amendment advocacy possible in the first place. Those two things together are the real story, not the panic, not the celebration, the actual legal reality you need to understand to protect yourself and your rights. We are entering a period where gun control does not always look like a politician giving a speech on television. Sometimes it looks like a payment processor sending you an email at 3 a.m. Sometimes it looks like a temporary court order you did not think was a big deal. The government has learned that it does not need to win a single massive battle against every gun owner. It only needs to win individual targeted battles against people who are not paying attention to the paperwork. The law is moving toward precision, toward narrow targeting, toward finding specific reasons to label specific individuals as outside the tradition. The best thing you can do in response is be the most boring, law-abiding, informed, and well-documented gun owner in your county, not because you are afraid, because you understand the rules of the game you are already playing whether you chose to or not. Most people do not lose their rights in a dramatic moment. They lose them quietly. In paperwork they skimmed, in hearings they skipped, in documents they did not read carefully enough, in messages they sent when they were angry and assumed no one was watching. The law does not grade on effort or intention. It grades on what happened, what was filed, and what you did next. Stay informed, stay precise. If you ever find yourself inside any of the situations we talked about today, a restraining order, a federal proceeding, a business being financially pressured, get a qualified attorney before you do anything else. Not a friend who knows a little law, not a forum post from someone who seems confident. A qualified attorney in your jurisdiction who understands federal firearms law, what those court documents actually mean, and what is genuinely at stake for you. This is educational information. Nothing here is legal advice, and nothing here creates an attorney-client relationship. But knowledge is your first line of defense, and you are far better off hearing this now than learning it for the first time standing in a courtroom, wondering what went wrong. Subscribe now because the next video covers the 3 essential items that should be in your glove box to make sure a 5-minute traffic stop does not turn into a 5-year legal battle. You do not want to be guessing when that moment comes. See you in the next one.